even a longish acting stint, once it is seen that you have what it takes and you are interested in staying on. Most of the candidates that make themselves available ultimately for appointment to the Supreme Court of Appeal have acted there at least for 4 terms. Then you know that you found your rhythm in the court. This is something you could really opt for. So as I say, maybe that's something that could be approached before we go to the radical step of amending the constitution. It's something to think about.
Thank you. Commissioner Nyambi?
Thank you. Sorry, I couldn't press my the comment on the independence.
Oh, sorry.
I'm sorry.
I'm sorry, Commissioner.
Singh,
Did I miss something?
The comment on the independence and the standing
okay.
committee of Auditor General, like we have.
Oh, no. But sorry, I forgot to.
Oh, okay.
That was a very useful tutorial. I did not know that such a dispensation exists, and that actually could work. That model could actually work for the judiciary.
Yeah. Satisfied, Commissioner Singh?
No, thank you very much, Chief Justice.
Okay, all right. Commissioner Nyambi?
Thank you, Chief Justice. Afternoon, DCJ.
Good afternoon, Commissioner.
Happy to see you. We all agree that the dignity and integrity of the judiciary is a key component of the rule of law and cannot be neglected. We'll also add that the integrity of the other two arms of the state, the legislature and the executive, is also very important. I'm also happy about how we have raised that issue in your earlier input. So, as a Chief Justice, you will head the judiciary. So, you will be a leader of the judicial arm of the state. You are expected to be that link if you consider the other two, the legislature and the executive. We have had some situations about some challenges sometimes. What do you think is the best way or mechanism for these three arms of the state to work in a way that will avoid sometimes where any other leader of this arm of the state will take a public platform and deal with the other one?
Thanks for that question, Commissioner. As I understand it, there is already an existing structure, a tripartite structure in which the CJ and other leaders in the other in the other arms sit, where they can they can discuss matters of mutual concern. I know that, for example, I think I mentioned that earlier in my vision that the Chief Justice has requested a meeting, for example, with the President and other relevant stakeholders to discuss the issue of the adverse impact of budgetary cuts on the judiciary's operations. So that is a platform that can be used successfully. There is another structure that the Chief Justice established, comprising him, Minister Lamola, and I think the Minister of DPW, which deals with issues affecting matters that are relevant for those departments. So it is not an impossible thing to have structures with representation from the three arms, which do not impinge on the boundaries of the separation of powers, but just to advance matters of common interest. I don't know if that answers your question.
Yes, it does. My second last question, it's It's about the journey, your journey. When I greeted you, I said happy to see you. It's because you are one of those that are fortunate in this commission. I remember as yesterday, the first time you came to be interviewed as the deputy president of the SCA, interviewed as president of SCA, interviewed as DCJ.
I've been here
So
many times, Commissioner.
as we're about to make that historic milestone, I know you are a woman from a rural village in the Eastern Cape in Zone. Can you please give hope to a poor African child that where you are born is not an impediment to what you can achieve in life?
Yeah. You've touched a nerve, Commissioner. Yes. Well, to first, this current generation uh, has social media platforms, so they are very savvy about what's going on around them. So they know of my existence, and the number of messages I receive from parents and guardians of young people who say we had no idea that someone who comes from a dusty rural village such as mine, Kutwala, can ascend to such heights, and we are very um, encouraged, inspired by you. Uh, I speak to young people. I go to schools, especially in the townships and in the rural areas where you have children growing up in dire situations where there's no hope. And I have had successful interactions there, and you'll be surprised at what you get in those places. The brains, the thirst for knowledge and to be someone in life, even in the most squalid, the poorest of where you find our people. So I would just repeat now what I always say to those children, that all you need to do is to just uh, reach out for the sky, and chances are that you'll land somewhere in between the ground and up there, and that opportunities are there for anyone. Doesn't matter, your background doesn't define you. If you reach out for opportunities and you work hard, then you chances are you'll make it.
Thank you, DCJ. Thank you, CJ.
Thank you, Commissioner Traba.
Thank you, CJ. Good morning. Good afternoon, DCJ.
Good afternoon, Commissioner.
Thank you very much. In the questionnaire that this body asked you to complete, you write that you lost a year of study owing to political unrest at the university where you were a student, and that during that period, some students were expelled, and that one of the student activists, lost his life in the hands of the Transkeian police. You certainly would not have mentioned this incident if it did not have a significant impact on your life or prepared you for future role, possibly as a judge. Am I correct?
Yes, indeed.
Thank you. What are the key lessons you learned from that incident, and how you have applied them to your role as a judge and or a leader of court?
Whew. And that's a sad reminder of a tragic time, Commissioner. Um, the lesson one drew from that experience was to stand for principle, for one thing, and the other is the constant reminder that what we have today came at a very high price. There are people who lost their lives for us to be here today. The, the student activist who was killed, you mentioned, was Batandwa Ndondo, who was our classmate, young man who died even before he began his life, just for aspiring to, get freedom for his country. So the most important thing for me, and it's not something I apply to my leadership, but it's just a constant reminder that makes me appreciate what we have today, that the people who paid the ultimate price for what we have, because his death was not in vain, by the way. It did achieve something precious.
Thank you very much, DCJ.
Thank you.
So can I just next follow-up question, CJ? Yes.
Yeah.
And can you explain how you incorporate legislative intent and historical context into your interpretation of laws and the Constitution? And in the process of explaining, cite examples, one or two, where you have given effect to this philosophy. Thanks.
Well, in the interpretive exercise, Commissioner, the first thing to remember is that the Constitution permeates all aspects of the law. So you are guided by that principle initially. I'm not sure what you mean by historical legislative intent.
The historical legislative intent versus the historical context, because all the time there's context to any legislation that is being passed.
All right. Well, as I was saying, we are guided by the Constitution that embeds the values of this democratic dispensation we live in. So the Constitution in itself already has the context that you need in your interpretive exercise. So I don't want to. I'm anticipating what you are asking me, but there's only one way of interpreting legislation or a document, and that is there are ground rules for that. To look at the context, the ordinary meaning of the words, the context. I don't know if that's you want the legal answer.
And to contradict the past that we
I
come from.
suspected that's what you wanted to. I keep what happened in the past in mind, and that's why I say the values that are imbued in the Constitution already take care of that, which you must take into account when you do interpretation. They already have that context embedded in it.
Thank you, DCJ.
Thank you, Commissioner Trevor. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon,
Good afternoon, Commissioner.
Justice Maya. I carefully listened to you when you shared your vision. If you are appointed as our Chief Justice, and I did so 2 years ago when you were here, and there's only one thing that I'm missing or I don't understand it in precision. If you are appointed, you will be the chairperson of this body, the JSC, at least for the tenure of your office, which will be about 10 years. Now, this body, for a number of reasons, has been in the spotlight in the past years. What is your vision about this body? Its composition, for example, the work that it does, because I'll tell you why I'm asking you this. This body is an intersection of all the state, organs of state. We, Parliament, with all our diversity and all of that, different political parties, we are here. The legal professions, here. The judiciary yourselves are here. And the government, represented by the minister and the 4 representatives, we are diverse with all the contradictions that you can think about. What is your view about this body? There's been a lot of criticism about this body, whether we are combative or not, our approach, how we asking questions, how we do our job. In short, what will be your vision for this body so that it becomes effective?
Thanks, Commissioner. Look, we all know that there's been a complaint especially from the legal quarters for a long time that there are too many, I'll put it crudely, that is what has been said. There are too many politicians in the Judicial Service Commission. Maybe it would work better if it was limited to more lawyers, more judges, and various formulations have been suggested. But I don't share that view. I think this body, as you point out, is one of the most, if not the most, representative of our society in the country. It brings together all these various members of the various formations that represent our people. And I don't think the problem lies in its composition. It must be said, at the risk of antagonizing the commission, it must be said that the manner in which the commission has conducted itself on occasion has maybe been, things could have been done differently. It has not been ideal. But this body took a conscious decision to review its processes, the way it conducts judicial interviews, and issued criteria not so long ago, which it is abiding by, and the evidence is there for everybody to see. As a result, you don't really get any complaints about the way it conducts itself anymore. There will be an odd complaint where maybe a favorite candidate has not been recommended, but that's something else. The commission is abiding by the rules it set for itself. And if I recall, there was also at one meeting, an undertaking was made that it would continuously review its processes, and that to me shows a willingness to do things the proper way. If there is this, the body realizes the need to, even though things seem to be all right now, but it recognizes the need to continuously look at itself to check if it is still conducting itself as it should. So in sum, I don't have a problem with the commission as it stands, its composition, and I think as long as it abides by the criteria it has committed to itself, then there's no need to change anything. You don't change what is not broken. You don't fix it.
Yes, CJ, in the interest of time, I'm okay. So safe to say, this job is nip up and placed.
I guess you sympathize with me. Thank you, Commissioner Muimang.
Thank you, Chief Justice. Good afternoon, Deputy Chief Justice.
Good afternoon, Commissioner.
Just one question from my side. One of the case that you have listed on your contribution to jurisprudence is the matter that involved the public protectors in an instance where the suspension by the president was set aside by High Court. Then the second aspect of that dealt with the suspension of a court order pending appeal.
That is the DA against.
That is correct,
Okay.
DCJ. If the DCJ can just illustrate as to why is this case important in terms of its contribution to the jurisprudence. The second point related to
Sorry,
that.
I didn't catch the question. Why?
Why is the DCJ of the view that it is important? It has listed it as.
Why have I listed it
as an important case
Oh.
in terms of your contribution to the jurisprudence?
All right. I have written only 3 judgments at the Constitutional Court, so I just thought, well, let me not say that, but I've only written 3 judgments, and I listed all of them just to show the commission the work I have produced while I was there. That was the reason. There are many judgments I've written, many judgments I've written as a single judge, and at the Labour Court and at the Supreme Court of Appeal, which I consider quite important. I've written judgments on various aspects of the law. For example, in tax, I've written in maritime law, but I've not listed them here because I don't consider them to be, they are not. I consider them to be just black letter law. And if you notice, you just check the other judgments I've listed. It's judgments that concern the rights of people, mostly about rape and cases involving Esther, Pi, the rights of farm workers and labor tenants and so on. So it is certainly not my best product. As I said, I just decided to list all the cases the judgments I've written in that court to show that at least I've written something.
The second aspect thereof also, you draw a distinction between, because there were 2 questions, you draw a distinction between the 2 in terms of cost orders. In relation to the first one, there is no postal cost orders granted in person. But in the second one, there is an order in relation to personal costing, personal capacity. So I also want to invite the DCJ probably just to elaborate on why the distinction.
All right. Well, the reasons are stated there in the judgment. The personal cost order, which I suppose is the controversial one, had to be made because the public protector, the office of the public protector, had deposed to an affidavit which distanced itself from that litigation, and it had made a provision to cover the former public protector's costs in the dispute, but not for this particular for this particular. Remember, there were three matters in one in that case. In this one, they said they had not given the mandate. They had not given any undertaking to meet her fees, and we found, as I recall, we found that that application was not necessary in any event because the matter it was already before the Constitutional Court was going to be heard, so it did not need to be launched at all, and someone had to bear the costs, and it could only be the public protector. But that was only in respect of one matter where there was no offer of a contribution by the public protector to meet her fees.
Thanks, DCJ. Thank you, Chief Justice.
Thank you. I only have 5 more names, and I propose that I don't add to those. Commissioner Makwanisha?
Sorry, CJ, as I was answering Commissioner
Thing?
Singh's questions, I saw that Commissioner Lucas had a hand up already.
She is the next one after
All right,
Commissioner
you have
Makwanisha.
her. Okay.
Yes.
No, thank you very much, Chief Justice. Good afternoon, Deputy Chief Justice.
Good afternoon, Commissioner.
No, let me start by appreciating the good working relationship in managing the transition between the Chief Justice and yourself. I think it's a very good way of managing a transition. I think it should be appreciated. It's also good for an organization like the judiciary to have that good working relationship. I only have 2 clarity-seeking questions, short ones. One, what is your view, Deputy Chief Justice, in the alignment of terms of offices of the Concourt and other courts? Remember, in the High Court and Supreme Court of Appeal, you retire at 70. And in the Constitutional Court, it has got a term limit of 12 years. What is your view on that? Should we have all the courts having the same term, or is the current position still a good one?
I know that there's been a concern that the Constitutional Court term costs the fiscus money because you have these judges who work only for a short time, and some had retired at very young ages and they go on and do other things. And you need to keep the skills and experience in the judiciary as long as you can. My answer, Commissioner, would be that there was motivation for the decision to keep Constitutional Court judges for that limited period. And other than what I'm raising now, the financial concern, I have not heard another compelling reason why the current dispensation should be changed. I'm not saying the financial consideration, especially as we are, the country is in dire financial straits. I'm not saying it's not important, but it seems to me that to tamper with an arrangement of this nature would need more than a financial concern. I doubt you'll be happy with my answer, but that's my honest feeling about it.
No, just seeking it was a clarity-seeking question. Maybe
Your voice is quite soft,
Soft.
Commissioner. I'm not sure that everybody can hear you.
Oh no, I was saying that Chief Justice. No, I'm fine with the answer. It was just a clarity-seeking question. And then the second one, Deputy Chief Justice, it relates to the issue of salaries.
Salaries.
Yes, the issue you raised earlier on. You remember there was a report in 2008 which developed a principle of parity of arms. And as a result of that report, the salary of the Chief Justice was paired to the salary of the Deputy President, the Speaker of the National Assembly, and the Chairperson of the NCOP. Now, you were saying that you should move away from the remuneration of public office bearers determining the salaries. So, are you suggesting that we should move away from that parity of arms and have a new, different dispensation for the judiciary?
Um, we, I'm just trying to find a tactful way of saying this. Let me say no, Commissioner. I am not proposing a different dispensation as speaking for myself, but there are representations that have been made by the judiciary to the IRC, which have not been given adequate, which have not been given a hearing at all. It's a detailed dispensation. Right now, the judiciary is still in talks with the remuneration committee. They must have a meeting, which has not yet happened, and I'm just hesitant to discuss the contents of that while it is still work in progress.
Thank you very much, Chief Justice. Thank you, TCJ.
Thank you. Commissioner Lucas.
Thank you very much, Chief Justice, and good afternoon to everyone. I really miss you, TCJ, and I think this is really, it's really very, very good to see you sitting here once again. I told you once that you are a trendsetter, and I told you once that you have broke the glass ceiling for many women, and I think Honorable Nyambi actually covered that part. But also on my introduction that I really wanted to bring, Honorable Magwanishe covered that, and that is the fact that the maturity that exists in the relationship between yourself and the Chief Justice, particularly with the transitional phase. So I think we have really came a long way as this body in terms of making sure that we address the issues of parity and equality. But in your view, how will you say you measure the progress that we have made with ensuring that we promote not only the appointment of women, but bringing about equality in the judiciary? I actually also want to add that I'm very pleased to hear that Lekgotla eventually took place where there is at least a kind of a semblance of, 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 of uniformity and also a kind of a semblance of a better working relationship throughout, and also en route to actually building one single judiciary where people doesn't feel that they are excluded, and where magistrate doesn't feel that there is not enough is being done to make sure that they feel part and parcel of judiciary. I also want to commend the fact that when appointed, you actually have you actually want to, in your own operations, make sure that you actually acquaint yourself with the courts in the country, because I realized that people will never feel important if you doesn't make them feel important, and they will feel very important if really their head, as you will be visiting them and making sure that you encourage them, so that also the image of judiciary begin to become, particularly in the eyes of South Africans, it sometimes can be so negative, or like what we are experiencing. We have been experiencing power outages for many years, but since load shedding, if the power just go out, people say load shedding again, load shedding again. So what I'm saying is that we've got a populace that are very challenging and sometimes very negative. So we need also to encourage those that are serving the people. And with that, you will really play a very good part. But my question, and I think maybe I must ask both so that I don't come back. is that how do you measure the progress that we have made with promoting equality, not only in the appointment of women to the judiciary and particularly to judicial positions, but also the issue of other groups, target groups that is there, like disability and so on. And secondly, you spoke about the financial challenges that you experience, particularly with regards to issues of training and development. And our experience have been that, particularly the magistracy, and I will mention just these two factors, the issue of on dealing with gender-based violence, but also the issue of dealing with issues of customary law. There is still challenges that we experience, particularly at the level of the magistracy. So in your view, how do you measure this, and what do you think you can do more to make sure that, particularly in training and development, but also in addressing the whole issue to promote equality? What more can be done, and how will your approach be? Thank you very much. And let me just conclude by saying, I wish you all the best. And we are very proud to be associated with you as a woman that have been making great strides in making sure that other women is also being empowered. Thank you.
Thank you, Commissioner. I'm going to answer the first question and then ask you to remind me of the second one. I didn't quite catch it. How do I measure the progress that has been achieved regarding, and I'm paraphrasing, regarding gender diversity in the judiciary? Is that a correct summary?
Exactly, but also adding on the issue of targeted groups like people with disabilities and so on.
All right.
Yes.
Thank you very much for that question, Commissioner. Significant progress has been made, but it's still not enough, as I said. Today we have a sprinkling of women judges in the leadership structures of the judiciary. I mean, we have President Molemela and two judges president, hopefully another one soon at the Land Claims Court. The candidate that was recommended by this commission recently for judge presidency of the Land Claims Court. So that is significant progress, and more. Look at the demographics as provided by this body of how many women judges there have been, and the numbers are still not enough. The magistracy has done very well in this regard as well. They actually have more women than men in that rank of the judiciary. Many of the women that are either in leadership in the superior courts or are in the courts, in the superior courts, come from this program that was just resuscitated, the Bridget Mabandla Aspirant Women Judges program. Most, if not all, the candidates of that initial program that was conducted many years ago were absorbed into the judiciary and have made their way up the ranks and are senior judges today. And that tells us that giving women a chance, offering them training and development, setting up these training and development programs actually works. And this is what is hoped the program in its revamped form will achieve. And in fact, the first crop of graduates from last year, we had, I forget now how many there were, but 19 of them were invited to act in the High Court. So chances are that most of them, most if not all of them, will become judges. So this concept works. And I don't think we have to do anything fancy. What you do is to source potential candidates. You look for people who promise to have what it takes, and you give them a chance. Either you train them or you invite them to act, as most women judges, have come into this sphere. They were given acting appointments from practice, from academia, and were absorbed. But we need to intensify that. All we need to do is to intensify that effort. Just intensify it, and it works. And the same applies to people with disabilities. Give those people a chance. We have a judge with a disability, Judge Munzelele, who by all accounts is doing well. She's doing as well as other colleagues. Her disability is not that does not impede her execution of her judicial duties. So you just have faith, and if people have a potential, if they've shown they have the merit to be given a chance, you give them the chance, and that's how you build a pool. I don't have a fancy answer for you, but that's what I've seen work. So that's what I would continue to agitate for, that you continue doing. And you have associations such as the South African Chapter of Women Judges, which conducts its own training for women and employs various measures to get women starting from young students who are mentored by judges and magistrates who are members of that association. Those people are likely to end up here in future. And you have SAULA, which is led by Commissioner Shabangu Mdawe, which does the same thing. So you just need to encourage, intensify the efforts that are already in place. They work. Just pour more energy into them, and you'll get the pool you need, and you'll get the numbers of women, competent women you need in the judiciary. Then the second one, all I had was challenges of relating to GBV and customary law cases in the magistrates court. What about those?
Thank you very much. Thank you, CJ. And I just want to say I like practical responses, and you were very practical in your responses, and I like that. The one on the magistracy, in fact, you spoke about the issue of challenges with your budget on training, and those of the issues that we have experienced in our in our consultation process was the lack of really sufficient knowledge at the level of magistracy on issues of gender-based violence and customary law in particular. So what I'm asking is that how innovative you can be to make sure that training and development at that level is being enhanced.
Well, we use the existing structure, the SAJ commissioner. We train using the SAJ.
I assume that answer is complete.
It is complete, Chief Justice.
Okay, all right. Commissioner Baloyi.
Thank you, CJ. Good afternoon, DCJ.
Good afternoon, Commissioner.
Yes, the first of my two questions. The first one is picking up from an earlier discussion that you had with the minister, and it is about if you achieved the independence, the administrative and budget independence that you seek or that you're proposing, how do you account for that? Now, I think in the discussion you clarified the position, I think, that you would have a mechanism through which you account to Parliament. But the first response of that, in the engagement, that the head of the judiciary would therefore would have to account to Parliament. At first blush, it would raise concerns about your views about the breadth and the depth separation of powers, of the concept of separation of powers. And perhaps we should hear, I know eventually it gets resolved because you say, well, there will be a mechanism because other jurisdictions have mechanisms, but to the extent that it implicates, that response implicates your own jurisprudential position of views about the separation of powers as a concept. Can you just speak more to that so that if there are any concerns about the Maya Chief Justice period being problematic when it comes to separation of powers, that can be cleared?
Well, this question arises only now that there is this quest for a totally independent judiciary commissioner. Until 2013, the entire judiciary, judges and magistrates, had their affairs run by the executive, the Department of Justice. And the question of, I remember when I was at the SCA, the president of that court, Justice Hawi, would rush to parliament with two other senior colleagues, perhaps to go and account for one thing or the other. This question of separation of powers, this concern was never raised. So I am not entirely sure. I don't see how it is offended if judges are actually. Oh, let me just preface this with the suggestion that was made by Commissioner Singh, by the way, on this committee that could be set up to address this. I think would be a perfect answer, take away any concerns there might be around that issue. But what I was saying is, I'm not sure why it would suddenly be a concern now that judges are actually running their affairs themselves and they go and give an explanation there, an explanation to the South African public, when previously they were in the clutches of the executive. They were given everything by the executive. The executive literally ran their lives. And the concern, which is the main thing that led to this proposal that we have this model, was that judges always had to go with cap in hand begging to the executive for this, that, or the other. And sometimes they didn't even have the opportunity to beg. They were just given, and they had to take that. So I don't think there's a real problem there. I really don't think so.
Yes. The second question is about, I think when you set out your vision, I agree when you say that as a judge, well, firstly, your first job is to adjudicate matters. And when you sit there, your vote is not any weightier than any one of your colleagues. I guess no one can argue differently about that. And yet there is the expectation that as Chief Justice and therefore head of the apex court, the court that finally pronounces on questions of law, there's an expectation, and you can say if it's an unfair expectation, that you would be the intellectual leader of that court. And so should there be or should there not be a fair expectation that you would provide leadership as the number one or as the expected intellectual leader of the court? If you agree with that putting that burden on the office of the Chief Justice, how practically in the period that you're Chief Justice would you go about realizing that goal of providing leadership, intellectual leadership?
It is not an unfair expectation, Commissioner. The reality of being a head of court is that you lead from the front in all aspects of your job. And you do that by sitting in court with the other colleagues and giving your input. I repeat that all judges, whether it's the Chief Justice is not going to persuade a colleague to go a certain way to agree with him simply because he's a Chief Justice. You persuade one another in the panel by presenting your reasoning, the way you view the issues and how the law should apply to those issues convincingly, which is counsel's duty, by the way, counsel having already laid the foundations in court. And I want to think that I've been able to do that. I'm trying to remember a case, for example, when I was at the SCA, where a colleague dissented in a matter in which I wrote, for example, and I can't think of one. So I want to think that there would not be a lag, I'm looking for the right English word. I don't think that there would be, it could be said that leadership was not provided in that regard. Whatever interpretation you want to give to the term leadership. But I just want to stress that when you have had a case, what position each judge holds in the court is irrelevant. It's how you view the case, and if you can persuade your colleagues to go along with you, then that's that. On that.
Thank you, DCJ. Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, DCJ.
Good afternoon, Commissioner.
DCJ, I just want to pick up on this question of full institutional independence that you've been dealing with in the course of the morning. Now, we know that the Office of the Chief Justice was created through a determination made by the Minister of Public, in terms of the Public Services Act. So there's no bespoke legislation in place which creates the OCJ and regulates its functioning. Do you think that that's a satisfactory state of affairs to give effect to full independence? Or do you think that it's necessary to have a bespoke piece of legislation dealing with it?
That is another area of concern for the judiciary, that you have an SG who is, for all intents and purposes, an employee of the public service, PSC, what do you call it these days? But it's a PSC official. This model we clamor for calls for a bespoke head of administration for our department.
And that would require bespoke legislation?
Yes.
And just then the second question, tying on to something that was raised by Commissioner Nyambi. Now, in paragraph 18 of your questionnaire, DCJ, you say that, and I'm just quoting what you said in your questionnaire because I found it quite profound. You say, I believe that my experiences as a Black woman from a rural background have provided the judiciary with a critical diversity of thought and valuable insights into a complex, vulnerable, and huge component of our society. Can I just ask you to just explain that a bit further, DCJ, and tell us specifically your experience as a Black woman coming from a rural background? How does that affect your judicial philosophy and also your leadership of the judiciary as a whole?
Thanks for that question, Commissioner. Diversity in the judiciary is a requirement precisely because of the different insights and perspectives each judicial officer brings to the job. That's why you need to have women, men, and there's the race component as well. And you break that down even further. It is important to have people coming from, the different uh, sectors of our society, and representing them there. For one thing, it engenders public confidence in this institution. For a woman, say, to see another woman sitting there adjudicating their case. It engenders public confidence in people coming from a rural background to know that there is someone who comes from their environment, who understands their needs and aspirations, sitting there deciding their issues. That's one part of it. And I don't know what more to say, but that's the effect. That's the importance, the important factor about having diversity in this institution. You pull in people with all these different experiences and insights, and they bring that into their judging.
Thank you, TCJ. Thank you, CJ.
Thank you. Commissioner Mangena.
Thank you, Chief Justice. Good afternoon, DCJ.
Good afternoon, Commissioner.
I too am filled with hope. Yesterday, we were told that the Supreme Court of Appeal has more women judges than male judges, but it also has more black judges than of other races. And truth be told, that is as a result of your intervention since you took over the leadership of that institution. And I want to say to you that this is a proud moment for our country. Brick by brick, the country is dismantling the apartheid legal order. And in less than 50 years, or in 30 years of democracy, the country has been able to do what other people could not be able to do in many years, the production of a woman Chief Justice. And you've got to be proud of yourself. But then, yesterday we were also told about the loss of expertise, more especially at the SCA. And it brought a question to me as a person sitting here in the JSC, that as people are leaving due to natural attrition, others should be coming. And I think that is where SAJE comes in, and the Act says that you are the chairperson of SAJE. In your vision, do you see a situation wherein there would be a proper program developed for the training of judges? Something similar to National School of Government, where there would just be a program, people interested in becoming judges go and enroll, and after obtaining the necessary qualifications, they may then be considered by this body.
Okay. First, thanks for the compliment. I just want to clarify that the credit is not entirely mine. The efforts to diversify the SA started even before my time, when the two women I found there were invited to the court and ultimately got appointed there. and then I came in. So the head of court who invited me actually is part of this process, and that was President Howie. And then Judge Mpati also did his bit. I only intensified what had already started. But thank you. And now about the loss of skill. You mentioned Sajay, and that is exactly where it fits in. But it is not enough. I recall that when I was at the SA, I don't know if, well, that project, in fact, fizzled out even before I left. We had started, well, not started because it's something that had happened, but infrequently. We had a peer training mechanism where we would invite colleagues still in the court to, I mean, you had people with various wide experience in various areas of the law, either still as sitting judges there or retired. I remember the person who started this, we saw this from, was Justice Harams, who is an intellectual property law expert, and he used to have afternoon sessions with us, just going over recent developments in the law, and which were very useful. So we built on that, and we would call other judges now, retired judges from that court, to come and talk to us about judgment writing and various uh, other aspects of our work. And everybody who participated in that exercise found it very, very useful. I mean, there are other creative ways we could we could employ to beef up the surgery. I'm not quite sure how far to take this, but the reality that we need to accept, Commissioner, is that black lawyers were excluded from these areas, the commercial work, these areas of the law, which are somewhat suffering now because you have more black judges coming in. That is the reality of our situation, and it's not the black judges' fault. They started on the back foot, and that is the reality of our past, and we have to contend with that. And I think I've said in this body before that the chickens of Bantu education and everything that was done to black people have to roast somewhere at some time, and we can't wait for the next generation. We can't wait for the commissioner, the commissioner Ngai Tobis, and the others who are excelling, Commissioner Nokesi, because we know that they are very competent and able black lawyers today because they've had opportunities maybe my generation did not have. We can't wait until those people are ready to come to the bench. We need to diversify the bench now, and we look for people with potential, but those people need help. So and that's part of how I feel about what you've raised.
Thank you, DCJ. Thank you, Chief Justice.
Thank you. That was the last commissioner to ask questions. I just want to return briefly, DCJ, to the issue that arose from one of the minister's questions, and that both Commissioner Baloyi and Commissioner Pillay also asked about. We might not need to discuss much further about it, but I think that at least for me, the problem about a judge or chief justice going to parliament to account as the executive ministers have been doing is that one, in terms of the executive, you have specific provisions in the constitution that require the ministers to report to parliament. And there are no such provisions relating to the judiciary. But of course, when you talk about funds, taxpayers' money, you can't have a situation where there's going to be no accounting. You know, at the moment, the accounting is done by the executive because that's the current arrangement. But one would prefer an arrangement in terms of which we keep our independence as much as possible and go for a model which doesn't require the Chief Justice or a judge to go and account to Parliament. And the model of an entity, organization, which is controlled by the judiciary, which might have a chief executive who does that, certainly appeals to me. And the model of the Auditor General is also one that appeals to me. So it avoids that situation that we are trying to move away from. But I have no doubt that having heard of the Auditor General kind of model, which you support, that's the one as Chief Justice, if you are appointed, that's the kind of model I think you would be pushing for. Am I right?
Yes, Chief Justice.
Yes. Right.
Chief Justice, can I just ask, this model of the Auditor General?
Yeah.
My understanding is that it's the Deputy Auditor General who accounts to Parliament. So how is this going to work now with the judiciary?
Well, I didn't understand that it's the Deputy General, the Auditor General, but maybe it is. I understood that it's some official. But in terms of the entity that I am talking about, it would be an official and not a judge in terms of the judiciary. It would be an organization such as the OCJ, where you have an administrator.
Should we not just leave this open for further consideration? Because if we leave it...
No, it's not final. It's ongoing discussions between us. Yeah, it's ongoing discussion. You know, I know what he's pushing for, and you may have heard what the JP this side said. He wants to continue to report on behalf of the judiciary. Okay, I think we've come to the end of this interview. DCJ, thank you very much for coming to this interview. Thank you very much for availing yourself. I think now you are excused.
Thank you, Chief Justice. May I just thank my colleagues. Well, first, the President for nominating me, regardless of what happens ultimately, but just giving me the opportunity. This commission for giving me this opportunity, and my colleagues and everybody else who has supported me for their support. I think that's the African thing to do. I'd like to thank them very much.
Thank you very much. We are at 22 minutes past 2. I think we should should take the lunch break. And shall we come back at 3 o'clock? Is that all right? Okay, we adjourn that.